Okay, yes, so we can go on the record now, please.
You're on the record, Your Honor.
Thank you. Good morning. This is the continuation of a hearing in the case before the Public Service Commission of Maryland, captioned in the matter of the application of Columbia Gas of Maryland, Inc. for authority to increase rates and charges. It is case number 9644. My name is Kristen Lawrence. I'm the public utility law judge assigned to hear this case. We'll start with appearances, beginning with the company, please.
Thank you, Your Honor. Carville Collins on behalf of Columbia Gas of Maryland. With me as counsel today is Megan Moore.
And OPC?
Hi, this is Gary L. Alexander on behalf of the Maryland Office of People's Counsel, and also with me is Frederick Hoover, and we are both Assistant People's Counsels. Good morning, Your Honor. Happy Friday.
Good morning. Staff? Mr. Wilson, you have to unmute yourself.
I'm a slow learner. Peter Wilson, Your Honor, on behalf of the technical staff of the Maryland Public Service Commission. With me is Catherine McErlin, and Kenneth Albert may be on as co-counsel. I see there's someone signed in as owner, but I don't see him specifically.
Okay. Mr. Collins, did you have additional exhibits you wanted to enter into the record at this time?
Yes, Your Honor. Happy to do it any way you would like us to proceed. I do have one piece of testimony and I believe a total of 3 or 4 exhibits to mark and move into the record. I'm happy to do it in the course of bringing the witnesses forward that you indicated you may have questions for, or we could just do all of them at the top, whatever you prefer.
The former is fine if you want to proceed with your witness.
Okay. In that case, then I would ask for Mr. Tubbs to rejoin us. And Your Honor, if you'd like to swear him in again, or whether maybe indicate that he's still under oath from last week's hearing.
I'll swear him in again. Mr. Tubbs, can you raise your right hand, please? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed, Mr. Collins.
Thank you, Your Honor. Good morning, Mr. Tubbs.
Good morning.
Do you have with you testimony in support of settlement dated and filed September 16th, 2020?
I do.
And is that testimony, is that prepared by you or under your supervision?
Yes, it was.
And do you have any changes, corrections, or updates to the testimony at this time?
I do not.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
And appreciate that you filed it very recently, but nevertheless, if you were giving this same testimony today, would your testimony be the same as when the testimony was originally filed earlier this week?
Yes, it would.
Your Honor, I would ask that the testimony in support of settlement dated and filed September 16, 2020 be marked as Columbia Exhibit, and I believe it would be 37 is next in the queue, if that's correct.
Yes, so marked.
And if there are no objections, I would ask that Columbia Exhibit 37 be admitted into the record.
Hearing no objections, Columbia 37 is admitted into the record.
Before I proceed with Mr. Tubbs, I wondered if I might just add one additional exhibit. This would be the settlement agreement, and that is formally styled as a joint motion for approval of settlement with appendices A, B, and C, filed September 16, 2020. If we could, I'd like to ask that be marked as Columbia Exhibit 38.
So marked.
And if there are no objections, would ask that Columbia Exhibit 38 be moved into the record.
Hearing no objection, Columbia Exhibit 38 will be moved into the record.
Thank you. Your Honor, my thought here would be to ask Mr. Tubbs just one question on live rejoinder about the settlement, and then afterwards, of course, he'll be available for any questions that you may have. And if that would be appropriate, then I would ask Mr. Tubbs to please explain the term revisions that have been made to the settlement agreement since the agreement was previously circulated and discussed in last week's case and last week's hearing.
Yes, there's just a few clarifying changes that were made to the stipulation of settlement. Top paragraph 1G regarding depreciation. The parties did agree to some clarifying language regarding the discount factor that the company may use in its next base rate case, and the parties' rights to challenge that discount factor in that next proceeding. In addition, there was some additional language added to both paragraphs 1L and 1M regarding the company's cross-bore and Picaro programs. That language stems from the staff's testimony in this case, asking for annual status reports on those programs, which we provided to the parties in this proceeding. And those are the only changes that were made. Carvel, I believe you're on mute.
Did you say something, Carvel Collins, please?
Thank you. Just one more question, and apologize for being on mute. Just for clarification, Mr. Tubbs, as to the language revisions in 1G regarding the discount factor, do you recall that these revisions and clarifications were made in response to the Public Utility Law Judge's comments and requests at our last hearing?
That is correct. Your Honor had asked for some questions that we went back and talked to the other parties and agreed that there some clarifying language would be useful in this paragraph, and hopefully this meets your needs.
Thank you, Mr. Tubbs. Your Honor, Mr. Tubbs is available for any questions that you may have.
Okay, thank you. And I am going to mute you, Mr. Collins, at this point. Or you muted yourself. Great. Okay. Mr. Tubbs, you probably remember last time we discussed that when the company originally filed its application, it had requested an annual base rate revenue increase of $6.5 million, which was an overall increase of approximately 14.3%. Do you remember that discussion?
I do. Yes.
Now, the settlement reflects an increase in the annual revenue requirement of $3.3 million. That's an overall increase of approximately 7.3%, correct?
That's correct.
The settlement, which has been entered as Columbia Exhibit 38 at Section L, this section authorizes deferral of expenses of up to $75,000 associated with the acceleration of the company's cross-bore program, correct?
That's correct.
This section of the settlement contains the following sentence. The company will include the deferred amount of no more than $75,000 and will include that amount in a future base rate proceeding and, if approved, amortize it over a 3-year period. Does the 3-year amortization mean that if $75,000 is approved as prudently incurred in a future proceeding, some portion of that amount will accrue interest until the deferral is fully amortized?
I'm thinking through your question, so just make sure I'm thinking through it correctly. I'm trying to think through. We've talked about the accrual of interest on the deferral. I think Jeff Newcomb may be better positioned to answer this question than I am, Your Honor.
Okay, I'll ask him.
Sure.
Mr. Collins, I believe that's all I have for Mr. Tubbs. I did have a question next for Ms. Hassan. I don't know if you were going to have her provide any rejoinder.
Ms. Bardis Hassan available, and so why don't we call her? She is the author of one request, and will be available for questions. So happy to bring her forward. Ms. Bartis Hassan, are you ready to go?
I just unmuted you.
Thank you. Yes, I am available and ready to go.
Great. And Your Honor, would you wish to swear her in before we proceed?
Yes, just okay. Ms. Hassan, there you are. Can you do you swear affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And Your Honor, the Ms. Bartis Hassan's testimony, I believe, has already been marked and moved into the record. So just one question that I have for Ms. Bartis Hassan is, are you the author and sponsor of bench data request 1-1 filed in this case on September 16th, 2020?
Yes, I am.
Your Honor, Ms. Bartis Hassan is available for any questions you may have.
Okay. Why don't we go ahead and move bench 1, or what you described as response to bench data request 1-1, move that into the record as bench 1. Does anyone have any objections to that? Okay,
No.
so that will be moved into the record as bench exhibit number 1.
Thank you.
Ms. Hassan, with regard to section K of the settlement, which is going to be exhibit 38, the operational order charges revenue provision, Mr. Tubbs, as you know, offered to have you respond to a question I had during the first part of this hearing last week, and that became the response to the bench data request that's just been moved into evidence. Part B of that response states, the company did not accrue interest at the company's rate of return on the $202,992, nor does the joint settlement provide for any interest to be accrued or paid on the $22,992. Operational order charge revenue is the result of transportation customer noncompliance with company-issued operational orders. The company's PGA customers did not pay for, nor were they billed any commodities or services associated with operational order charges revenue. Therefore, the company did not assess interest on the amount to be passed back to PGA customers. Further, the company did not violate its tariff or any existing regulation by retaining the operational order charges revenue of $202,992. So there is no regulation, guideline, or rule that requires the company to pay interest on operational order charge revenues. Is that correct?
That's correct.
And that is why the settlement does not provide for interest to be paid on the $202,992, correct?
That is correct.
Mr. Collins, that's all I have for Ms. Hassan.
Thank you, Your Honor. Next, I will ask Jeff Newcomb if he is ready to proceed.
I am ready.
Mr. Newcomb, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Collins, did you have an opening question for Mr. Newcomb?
Yes. Mr. Newcomb, good morning. For the record, would you please state your employer and title?
Yes, my employer is NiSource Inc., and my title is Manager Regulatory Rate Cases.
And do you have before you a revised exhibit? It's styled as revised JDN 1-R, R as in rebuttal, dated and filed on September 15th, 2020, providing updates on Columbia's actual rate case expense incurred through September 11th, 2020 for case number 9644, together with copies of the actual invoices.
Yes, I do.
And was this exhibit prepared by you or under your supervision?
Yes, it was.
Do you have any changes, corrections, or updates to the exhibit?
I do not.
Is your exhibit true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
If you were providing this same exhibit today, would your exhibit be the same as when the exhibit was originally filed?
Yes, it would.
Your Honor, I would ask that the exhibit, the revised exhibit of Mr. Newcomb, JDN 1-R, dated and filed on September 15th, 2020, be marked as Columbia Exhibit 39.
So marked.
And if there are no objections, I would ask that Columbia Exhibit 39 be admitted into the record.
Hearing no objection, Columbia Exhibit 39 is entered into the record.
Thank you, Your Honor. Mr. Newcomb is available for any questions you may have.
Mr. Newcomb, Mr. Tubbs indicated that you were the person I should ask this question of, so I'm going to ask it again. The settlement at Section L authorizes deferral of expenses up to $75,000 associated with the acceleration. Correct.
Correct.
This section of the settlement contains the sentence, the company will include the deferred amount of no more than $75,000 and will include that amount in a future base rate proceeding and, if approved, amortize it over a 3-year period. Does the 3-year amortization mean that if $75,000 is approved as prudently incurred in the future proceeding, that some portion of that amount will accrue interest until the deferral is fully amortized?
Our typical practice is not to accrue interest on expense deferrals, so we probably would not.
What might change to change that usual practice?
A longer amortization period, so timely recovery might impact that practice.
So I guess I'm trying to understand what you're saying. A 3-year amortization, it's not worth accruing interest, but longer than that, it might be. Is that what you're saying?
I'm saying it might be something that we would consider, but again, our typical practice would not be to defer interest on an expense deferral.
So when will a determination be made on whether or not there'll be interest on the $75,000, the portion of that that's not fully amortized in the first year? When will a decision be made as to whether you'll accrue interest on that amount?
So at this point, we are just requesting approval of the deferral mechanism. So until we have deferral, that approval, I don't think we would make a decision until we have approval for the mechanism.
But you wouldn't expect to necessarily accrue interest on any portion of the $75,000 over that 3-year period that's being deferred?
That's correct, Your Honor.
The settlement does not address employee travel expenses or airplane lease and charter expenses, correct?
That is correct, Your Honor.
You took the position in your rebuttal that any reduction in these types of expenses related to COVID-19 will be addressed as directed in an April 9, 2020 order the Commission issued authorizing Maryland utilities to create regulatory assets for incremental COVID-19 related costs and should not be addressed in this proceeding. So so the record is clear, the settlement does not incorporate a reduction in employee travel expenses, correct?
That is correct, Your Honor.
So any reduction in employee travel expenses will be credited in the company's regulatory asset for incremental COVID-19 related costs, correct?
That is correct, Your Honor.
Okay, Mr. Collins, that's all I had for Mr. Newcomb.
Thank you, Your Honor. I believe on my exhibit list, there's just one more for marking. That would be the safety and reliability expense work papers, which provide support for safety and reliability expense in the 2 months, June and July of 2020. It is formally styled as Revised Exhibit 8 Rebuttal. It was filed on September 15th, 2020 in this case, and I would ask that that be marked as Columbia Exhibit 40.
So marked.
And if there are no objections, I would ask that Columbia Exhibit 40 be moved into the record.
Hearing no objections, Columbia Exhibit 40 is moved into the record.
Thank you, Your Honor. That concludes my list of testimonies, exhibits to be marked and moved into the record. And we are prepared to conclude unless you have any other questions or issues for us.
No, we'll proceed to OPC. Mr. Alexander?
Thank you, Your Honor. We're going to call Lafayette K. Morgan Jr. to the stand.
Mr. Morgan, I've unmuted you. Can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You can proceed, Mr. Alexander.
Thank you. Mr. Morgan, would you kindly state your name for the record?
My name is Lafayette Morgan Jr.
Would you please state the name of your business and its address and location?
I work with Exeter Associates in Columbia, Maryland. The address is 10480 Little Patuxent Parkway, Suite 300, Columbia, Maryland, 21044.
Thank you. Would you please state the position?
I'm having trouble hearing. Somebody's moving papers around on the desk and it's being picked up.
I think it's Fred.
Okay.
No, Fred is muted.
Oh,
Yeah, he's muted. I saw it, but it looked like he was moving at the same time the papers were moving. So I don't know what the story is. But it's cutting out whatever this gentleman is saying.
Do you need Mr. Alexander to back up a question?
yeah, sure.
Okay.
Did the court reporter hear the name of and address of the business?
That was missing because I just kept hearing papers slide across the desk. It was
Well,
very-
then, that's okay. I'll ask it again. Mr. Morgan, would you please state the name of your business and its address and location?
I work with Exeter Associates. The address is 10480 Little Patuxent Parkway, Suite 300, Columbia, Maryland. The zip code is 21044.
And would you please state the position that you hold in the business?
I am a utilities consultant.
Are you the same Lafayette Morgan Jr. who previously provided in this case direct testimony, followed shortly thereafter by corrected direct testimony?
Yes, I am.
Mr. Morgan, do you have before you a document entitled Supplemental Testimony of Lafayette K. Morgan Jr. on behalf of the Maryland Office of People's Counsel, dated September 16, 2020, filed in this case? That is case number 9644.
Yes, I do. I have it.
And does that document include 11 pages of narrative testimony?
Yes.
Your Honor, I respectfully request that Mr. Morgan's supplemental testimony be marked for identification as OPC Exhibit 8.
So marked.
Thank you. Mr. Morgan, was this testimony before you, prepared by you, or under your supervision and
Yes, sir.
direction?
Yes, it was.
Do you have any corrections or deletions to make to your testimony at this time?
There are none at this time that I'm aware of.
If you were asked the same questions today under oath as were posed in your pre-filed supplemental testimony, would your answers be the same?
Yes.
For these reasons, do you adopt this supplemental testimony as your sworn testimony in this matter?
Yes.
Your Honor, I move that OPC Exhibit Number 8 be admitted into evidence in the record of this case.
Hearing no objection to that, OPC Exhibit 8 is entered into the record.
Your Honor, the witness is now available for examination.
Mr. Alexander, I don't have any questions for Mr. Morgan, but thank you for appearing today.
Oh, thank you, Your Honor.
All right, Mr. Alexander, does that conclude your presentation this morning?
Yes, because the agreement was already entered into evidence, so yes.
Okay, thank you. We'll proceed to staff. Mr. Wilson?
Yes, Your Honor. Staff, at your request, has Ms. Proboreski available for your questioning.
Okay, and thank you. I'm gonna mute Mr. Morgan. Ms. Poboreski, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Sorry to drag you here on your last day.
I'm happy to be here.
Okay. Did you listen to Mr. Newcomb's testimony?
Yes.
Did you understand his testimony?
I do understand it in a sense. Are you talking about the deferral of 75,000
Yes.
for cross-border?
Yes.
My understanding that until at this point, it's just a deferral of all costs in the future. And in the next rate case, the company will come and present the amounts that they incurred for that program for staff's review, and then it will be reviewed and for prudency and prudency of costs, and engineering will review that everything related to those costs are indeed connected to the program. And then only then it will be included in the cost of service. And at that time, we can discuss whether interest should be or should not be. Not interest, but all the carrying charges should be or should not be included with the amount. So
Okay.
I agree with Mr. Newcomb that at this point we do not need to discuss carrying charges for that program.
So the fact that the $75,000 is proposed to be amortized over 3 years, if that were to happen, it doesn't necessarily mean that it would have carrying charges associated with it.
It would be up to the commission to decide. My understanding is the parties may propose it to be recovered with carrying charges or without carrying charges, but the commission can decide on that at a later time.
Okay. Don't utilities typically take the position that if they aren't able to recover carrying charges when something's amortized over a period of time, then they don't get full recovery of the amount spent?
I think there are regulatory assets that accrue carrying charges, and there are some that the commission specifically decide that they shouldn't accrue any carrying charges. So again, both options are available, and the discussion can be continued into the next rate cases when the costs are actually included and presented for the parties' review.
Okay, thank you.
You're welcome.
Mr. Wilson, that's all I have for this week.
The staff has nothing else, Your Honor.
Okay. If none of the parties have anything else, I believe that concludes our business at this hearing. Mr. Collins, you want to confirm that? You have nothing else?
Thank you, Your Honor. We have nothing else. Thank you very much for your courtesy, and we appreciate it very much. Thank you.
Thank you. Appreciate everyone's cooperation today. We are adjourned.
Thank you.
We're off the record, Your Honor. Thank you.